Good morning. This is John Chapman from Clark's Legal. Today I'm going to give a relatively brief introduction, summary of where we've got to, an update on data protection insofar as it relates to employment. I'll also add to that a bit of an overview on freedom of information, which is an area which is related to data protection but has some significant differences. The current EU data protection regime is based on a directive that was introduced way back in 1995, and our Act is a 1998 Act. You won't need me to tell you that quite a bit has changed since then. There have been huge advances in IT and very big changes in the ways in which we as individuals and organisations communicate and share information with each other. In an attempt to bring this all up to date, the EU has published in May this year the General Data Protection Regulation. This gives businesses 2 years to comply, and it will be replacing the 1995 directive fully with effect from 25th May 2018. You will inevitably now say to me, how does that sit with Brexit? Well, the answer is, like many other things, we don't really know. There's a great deal of uncertainty about where we'll end up. What I can say, though, is that the position that the Information Commissioner's Office has taken on the General Data Protection Regulation is quite useful. Their statement is that many of the principles in the new legislation are much the same as those in the current Data Protection Act. If you're complying properly with the current law, then you have a strong starting point to build from. There are important new elements, and some things will need to be done differently. These new elements include matters such as consent to processing, which will impose a higher standard, how subject access requests are to be dealt with, enforcement and penalties, and so on. Because of the uncertainty, though, it's probably better not to second guess where we're going to be in 2018 with that, and revert to what the ICO says is the strong starting point. In other words, ensuring that you are, quote, complying properly with the current law. So for that reason, I'm going to just look at a few general principles which underpin everything in data protection, and it doesn't matter whether we're talking about personal data being processed for employment, marketing, or health records, and then we'll drop that down to the employment context. So the Act itself sets out when personal data can lawfully be processed and how it should be processed. It's vital, accordingly, to be aware of and understand all the principles that are set out in the Act before we go on to specific contexts. What is data under the Act, and where can we find it? Well, there's two sorts of data. There's online data, which is defined as that being processed automatically by equipment, or data recorded with the intention for it to be processed this way. Usually, of course, that will be information which is held on a computer, but there are other relevant media, and I will get onto those in the employment context later. As well as online data, there is manual data. For manual data to be possibly data within the Act, it has to form part of what is known as a relevant filing system. Relevant filing systems are systems that are structured in a way that clearly shows at the outset of any search where the personal data is held on the system and where that personal data is. There's a test which the Information Commissioner's Office have referred to, which is called the temp test. And this is quite a useful way of looking at where the data that is held manually forms part of a relevant filing system and could come within the Act. So the test is, if you employed a temp, would they be able to extract specific information about an individual from your manual records without having any particular knowledge of your type of work or the documents which you hold? So if multiple categories of information are held in one particular manual file, you do not have a relevant filing system, so you don't fall within the Act, if this putative temp would have to plough through all the different categories of information to find the specific information needed about an individual. So once we've established what sort of data we can be talking about, whether it's online or manual, the next thing is it personal data or sensitive personal data about a data subject within the Act? Personal data must relate to a living person in some way. Relate really means that it can be used to inform or influence decisions. That's Information Commissioner's Office view. The individual, the living person, must be identified from that data alone, or from that data and other information, which is held by or likely to be held by the data controller. And obviously, the data must be about that person. It must be data which in some way impacts on them, or may impact on them, affect their privacy, or have them as its focus. The information does not need to be fact. It may be an expression of opinion, for instance, about that person. So that's personal data. Sensitive personal data, which has slightly different treatment in the way it can be processed, is specific categories. And this is racial or ethnic origin, political opinions, religious beliefs or beliefs of a similar nature, information about trade union membership, information about physical or mental health or condition, and information about sexual life. So where might we find data in an employment context? Well, remember, online data is data which is processed automatically by equipment. So obviously emails could fall within this category. An email from a manager to HR about someone and what they've been doing, for example. Computer databases and manual filing systems, providing they're part of a relevant filing system. Interestingly, telephone records, CCTV records, internet logs, payroll systems, and records of automated door entry systems, for instance, swipe cards, also constitute data potentially within the Act. And there may even be sensitive personal data. So there are circumstances, for instance, where swipe card use might constitute sensitive personal data because it may give you information were you to analyse it about someone's health condition. Manual data is clearly date-ordered or subject-ordered files, card indexes, written or typed personnel files for multiple employees which are divided into sections using dividers like leave records, named individual personnel files, holiday records which are collected in a structured way. So all of this material is capable of falling within the Act. Sensitive personal data will be stuff such as sickness records, medical questionnaires which are taken pre-employment, possibly interview notes during the recruitment process, the results of drug or alcohol testing, which a lot of employers do now. Private health insurance records might contain details about a personal sexual life, for instance, if a beneficiary is a partner. And criminal record checks, all that sort of stuff needs to be looked at carefully in the context of obligations under the Act. So who are these data subjects in the context of employment? Really, just about everybody that the HR department might come into contact with. So it could be current and former job applicants, even those who've failed. Obviously employees, current and former. Agency, contract, casual workers. Volunteers are within the Act potentially in relation to their personal data and sensitive personal data, as are interns and work placements. So what do we mean by processing data? Well, processing data in an organization is basically everything that an organization may do with data from cradle to grave in that data. So obtaining it in the first place, recording information, organising it, putting it into that structured way we've talked about in manual records, retrieving information and accessing information, using it, and this is particularly in a way that informs or influences a decision about the data subject, altering the information, disclosing it to a third party, and then finally destroying the information. Everything that is done in terms of processing information is underpinned in the Act by 8 data protection principles, which apply to all sorts of processing, however it's done. These are relatively clearly set out, but beneath them there may be quite a large amount of case law and practice, particularly the first, which is that information must be fairly and lawfully processed, and not processed in the case of personal data unless at least one of some conditions known as Schedule 2 conditions are met, or for sensitive personal data, Schedule 3 conditions are met. And I'll just get on to those later. It's also necessary to fairly and lawfully process data that you inform your employees of the purposes for which the data are intended to be processed. Principle 2, processed for limited purposes. Don't use the data for more than you need to use it for. It must be processed in a manner which is adequate, relevant, and not excessive in relation to the purpose. It must be accurate and up to date. It should not be kept for longer than necessary. It should be processed in line with data subjects' rights, and this is particularly a reference to subject access request rights. It must be kept securely, so you need to have in place, whenever you're a data controller, an organization that is holding personal data about a data subject, or indeed a data processor, an organization which is processing personal data on behalf of a data controller, you must have in place appropriate technical and organizational measures to prevent unauthorized or unlawful processing, and which also prevent accidental loss, destruction, or damage. And finally, the 8th principle is you cannot transfer personal data or sensitive personal data to other countries without adequate protection being in place in the recipient country. So fairly and lawfully is a very wide area as the first data protection principle. In an employment context, it really means you've got to keep your employees informed about the records that are being kept about them, or which may be kept about them, why they're being kept and processed, and then the circumstances in which that data, those records, might be disclosed to third parties. Now, a starting point for this, keeping your employees informed, is probably your staff handbook or intranet. But you may need to do more than that in certain instances, particularly sensitive personal data. Talking about ordinary personal data, then it is necessary to comply with what are called Schedule 2 conditions as well. The ones that are relevant in the employment context are probably the following: where the data subject has given their consent to the personal data being processed. This seems pretty obvious, but there's a little bit more to consent than might meet the eye. The ICO, the Information Commissioner's Office, considers that the extent to which consent can be relied on in the context of employment is limited, since it's often possible that that consent is not freely given. In other words, if the consent is set out in an employment contract and you refuse to accept that clause, are you potentially running the risk of losing the opportunity to take that employment? Court decisions on consent be unambiguous, so silence implying consent doesn't necessarily work. It's got to be specific and informed, so the employee, the data subject, must have been told clearly what types of personal data are involved and will be made of that data and on what occasions, and it should be freely given. So this is what I've referred to earlier. Is it really freely given if it's in a job offer and an employment contract? Another Schedule 2 condition, which may be of use, is that the processing is necessary for performance of a contract to which the data subject is a party. So here we have an employment contract, and it is necessary to process personal data for the purposes of that contract. So payroll records is an obvious example of that. Also, there is an exception, there is a Schedule 2 condition which can be complied with where the processing is necessary to comply with legal obligations to which the data controller, the employer, is subject. So, for instance, providing tax records to HMRC or disclosure in legal proceedings. Where we're talking about sensitive personal data, we need to comply with what are called Schedule 3 conditions. The ones that may be relevant here, and there's quite a number, are, again, a requirement for data subject to give explicit consent to the processing. This is not really defined any differently from consent in the context of personal data. The ICO's view is the employee should have been told clearly the personal data involved, told the use made of it, or what will be made of it. They've given a positive indication of agreement, such as a signature, and they must have a real choice about whether to give consent or not, and not suffer significant detriment for refusing. This is problematical because it may well be necessary to keep ranges of sensitive personal data as an employer, and whether this real choice then can be complied with is questionable. However, there are other exceptions which I'll get onto which may help. Blanket consent to processing of sensitive personal data may be okay in certain circumstances, but cannot necessarily always be relied upon. So certainly the starting point should be telling clearly and explicitly, telling your employees what you are doing with sensitive personal data in something which is accessible to all of them, be it the intranet, the handbook, or whatever. Another Schedule 3 condition which allows you to process sensitive personal data is where it's necessary to exercise or perform a right or obligation imposed by law on the data controller. So this is a useful exception because employers have a large number of legal obligations which may involve processing sensitive personal data. It may also be possible you can comply with a Schedule 3 condition which allows you to process sensitive personal data to ensure health, safety and welfare at work of workers. So this is much used, for instance, in the context of reviewing night worker health assessment records to ensure that the working time regs have been complied with. And there are exemptions from fair processing and subject access rights for a number of other matters. Disclosure required by law or by court order, required in connection with legal proceedings or prospective legal proceedings, or to obtain legal advice, or where data, be it sensitive or ordinary personal data, is processed to prevent or detect crime or apprehend or prosecute offenders. So, data protection issues at the start of employment and through to the end of employment. Well, they arise right at the start with the recruitment process because obtaining the personal data, and sometimes the sensitive personal data that is obtained in the context of recruitment, is obviously processing, and so the Act will apply. Application forms are your starting point, be they manual or online, and as a matter of good practice, you should only ask for information which is strictly relevant to the recruitment decision. And in an ideal world, although this isn't necessarily always practicable, they should be tailored, the application forms, to the particular job. For example, it's probably not appropriate in a data protection context to ask someone applying for an administrative post about their driving record, but it is wholly appropriate to ask someone applying for a driving job about that. The problem with using generic application forms is that the information about the driving record for the administrator will go onto the system, and it isn't necessarily fair processing in that circumstance. If there is a need to seek sensitive personal data at this stage, ask yourself again, is it really necessary at this stage of the recruitment process? It may do, but make sure you are selective and careful about its use. If you use an online application form system, it's clearly important that you have security measures in place to ensure that access is limited to those involved in the process and on a need-to-know basis. There should be a policy for disposal of unsuccessful or unsolicited applications, though you may tell applicants, for instance, that their application will be kept on file for a certain period in case any future vacancies arise, unless they object, and that is perfectly appropriate. If you carry out equal opportunities monitoring, like many employers do now, questions on forms should be designed to ensure that the information collected is wholly relevant to this monitoring process and nothing else, and that it is accurate and it's not excessive. This is principle 3. And if you gather this information, the best way to deal with it is that it's anonymized, at which point it ceases to be personal data because the personal data subjects who provided it are no longer identifiable. So once we've taken someone on board as an employee or as someone else within our organization, we have a series of records. We create and retain records. If we have any personal data about that person, it should be only that which is required to meet an organizational need and nothing that is excessive. Remember principles 2 and 3 on the list, which are processed for limited purposes, adequate, relevant, and not excessive. The data should be accurate and kept up to date. Employees should be asked regularly to update information and have the opportunity to do so in an unsolicited way. But you should ask regularly on for instance, an annual basis or something like that. Give them the opportunity to change their personal data on the system. It goes without saying that security of information held is very, very important indeed and can lead to significant reputational issues if that security is compromised. So take account of the risks of unauthorized access, accidental loss and damage, and ensure that is addressed. If we're talking about sensitive personal data, as I've said before, be careful not to collect and hold more information about, for instance, health than is strictly necessary. It's common sometimes for medical reports to be obtained pre-employment, but these should focus strictly on the employee's fitness for the particular job, the particular tasks that will entail, and shouldn't include information that is not relevant to the role. Consider if there's a less intrusive way of obtaining this sort of information, for instance by a questionnaire rather than a medical examination. Although again, the questionnaire should only be seeking relevant and necessary information. Medical examination and testing should not really occur unless there's a real likelihood that the employee, the person in question, will be appointed to the role. There aren't any specific document retention periods under the law, so you need to set your own time limits by thinking carefully about how long you need to hold particular sorts of information. Blanket policies of deletion are not really acceptable because these indicate that you haven't given specific thoughts to how long you should hold particular categories of information. You need to take account of legal obligations or risks as an employer in future. PI claims are a very good example of this. In some industries, there is a very long overhang between an employee leaving and a potential PI claim. We look at industries like mining and industries involving the use of asbestos for these. There's a duty to cooperate with HMRC investigations, and these may take place several years after the relevant tax year. So that sort of information, it may be necessary to retain it. Or you may just need to defend an employment tribunal claim, so you need to keep information for a particular period to address that. As a general principle, don't be an information hoarder. Give proper specific thought as to where the personal data you're holding is really needed. So moving on now to subject access requests. This is a right of a data subject to make an access request to find out what information a data controller holds about them. The request must be in writing. There must be a £10 fee paid. There needs to be evidence to confirm that the individual is who they say they are, and there needs to be information, so much as is possible, which allows the data controller to locate the information sought. Well, clearly, as I've said at the outset, the type and amount of data held by employers has grown massively since subject access rights first came in over 30 years ago. There's a huge amount of electronic data held by employers, and we've seen all the technological developments and extensions of the directive to manual data, which means that subject access requests now are potentially extremely onerous, and far more so than when they were first conceived. The courts have held that the main purpose of subject access rights is to enable an individual to check whether their data is being processed unlawfully in a way which infringes their privacy. So there are 4 rights embodied within subject access rights. The first is to know if data is being processed about you. If it is, to know what sort of personal data is being processed about you, the purposes for which it's being processed, and the types of people to whom that data may be disclosed. The third right is to have the information being held about you, which constitutes personal data, given to you in an intelligible form. That obviously means a form which is not some form of computer coding, which it would take a genius to work out. It has to be an intelligible form. And the fourth right, which is a lesser used one, but one which may increasingly become important, is the right to be informed of the logic of automated decision taking, where you have a process which sifts out job applicants, for instance, and that is done by computer rather than personally. Now, the Court of Appeal, in a landmark case called Durrant, has said that the primary purpose of subject access rights is not to help someone get access to documents that may help them in litigation or complaints against a third party, such as the employer. This is the so-called fishing expeditions. But litigants and potential litigants do use subject access rights to help them in litigation or potential litigation, and they're often used, I have to say, in disputes between employers and employees. There are no exceptions to subject access rights in the context of live disciplinaries. So if you are going through a disciplinary process with an employee, you cannot refuse an SAR from them on the basis that there is a live disciplinary process going on. The Act will seek to prevent vexatious requests, for example, because one's been made earlier which was similar or identical to the one that's been made now, unless there's been a reasonable interval. So what do we do when confronted with an SAR? Acknowledge receipt quickly as possible. Bear in mind there is a 40-day time limit. Do you have enough information to identify the employee and the data? If you don't, get in touch with the employee quickly and request clarification. Make sure you have someone in the organisation who's got overall responsibility for pulling all the strings together, getting the data, ensuring an adequate search is carried out, putting the responses together, and if necessary, and I'll get onto this, editing third-party data. Make sure all the stakeholders in areas of the business that might be relevant understand what is expected of them. The search may include, obviously, databases, emails, CCTV records, telephone records for landline and mobile phones, internet logs, and as I've said before, payroll systems and even swipe card details. Obviously, there shouldn't be any deletion of data which on the subject of an SAR unless it would have been deleted in the ordinary course of events. In other words, I don't think you're required to stop your normal automated deletion systems, but you shouldn't be doing any deletion on the basis that we should get rid of this because an SAR may come in about it. Consider whether you need to seek consent from any third parties who could be identifiable from the data which you're disclosing under the SAR. If this is likely to lead to a delay, send the person who is making the SAR notification of this as soon as possible. And consider whether there's any exemptions from disclosure, which I'll get onto in a minute. And you need to respond within the 40-day time limit, and you should, if at all possible, as a matter of good practice, explain to the person making the request what type of data you've provided and whether and for what reasons any has been withheld. This clearly quells any potential fires and is a good thing to do. So how far do we need to go in the process? Well, you need to make a reasonable and proportionate search. There's a very good case on this in the Court of Appeal which indicated that not all the information retrieved from a computer search against someone's name or unique identifier is personal data. The mere fact that someone is mentioned in a document held by a data controller doesn't necessarily amount to their personal data. Whether it does so in any particular instance depends on whether it falls in a continuum of relevance or proximity to the data subject, as distinct, for example, from transactions or matters in which the subject may have been involved to a greater or lesser degree. To cut through that, passing references to someone in an email chain where they're not really the focus of that email chain does not constitute personal data. The Information Commissioner's Office takes a fairly hardline view on obligations under SARs and says it will never be reasonable to deny access to the requested information merely because responding to the request may be labour intensive or inconvenient. There is a slight amount of tension between the court view and the ICO view, and I do think we need a higher court, probably the Supreme Court, to come out with a definitive view on this. The sort of data that you have to look at in the process, as I've said, could be very significant. And the ICO also takes the view that data may be within the scope of a subject access request if it's been deleted, particularly recently, but it is technically recoverable. For manual data, you need to apply the temp test, which I've referred to before. There isn't, as I've said, and I'll emphasise this, an express provision permitting an employer to refuse to respond if it considers a request to be onerous. And the ICO's Code of Practice on SARs sets out in a useful fashion their view on difficult to access data. Now, you don't have to comply with an SAR if the information relates to a third party who could be identified from that information, unless that third party is consented or it is reasonable in all the circumstances to comply with the request without that consent. Quite often it's possible to edit out or redact the details of the third party, but you need to be a bit careful on this because even with good editing stroke redaction, you may be able to identify the third party because of these circumstances and the context in which the deletions occur. Exemptions. Well, there are some quite significant ones. Data processed in connection with management forecasting or planning is not required to be disclosed to the extent that it would prejudice the conduct of the business. So we're talking here about management strategy and so on. Records of intentions in relation to negotiations between the data controller, the employer, and the data subject, the employee, do not need to be disclosed if that would prejudice those negotiations. If data is subject to legal professional privilege, so for instance it's the subject of a solicitor's letter of advice, doesn't need to be disclosed. Health records in response to a SAR do not need to be disclosed if their disclosure would be likely to cause serious harm to the physical or mental health of the employee or any other person. So finally, disciplinaries. All the general principles that I've talked about earlier apply. If you're conducting an investigation into alleged misconduct, the key is that the process you follow must be proportionate and cognizant of your obligations as a data controller. It must recognise the seriousness of the matter and everybody else's right to privacy. So if you access a massive number of employees' personal emails to track down a culprit for something which may not be that significant, that is not likely to be justifiable because it's disproportionate. And that is even if those employees have been told that their personal emails might be accessed in certain circumstances. Disciplinary records, of course, must be kept securely. They're personal data, and the number of people with access to them should be kept to the minimum necessary for proper administration. But really, disciplinaries are just a subset of processing of data, and the general principles need to be borne in mind. So that really is it in a relatively brief run-through of data protection in employment. I'm going to conclude by moving on to freedom of information. Freedom of information is a concept which was introduced by the Freedom of Information Act in 2000, which was aimed at public authorities and making them more transparent by allowing the public a way to find out more about their policies and decision-making processes. So what public authorities, the ones that must disclose information under FOI requests, are government departments, local authorities, educational institutions, any state-owned companies, and a whole mass of other public bodies. But there must be some public nexus for the body in question to be subject to the FOI requirements. Individuals and companies have the right to ask public authorities whether they hold certain information, and if they do, the right to be given that information. So in a sense, this is analogous to a subject access request. The whole area of freedom of information has created some new risks for businesses because commercially sensitive information which they have created and passed over to a public authority may become disclosable under FOI principles and thus more easily available to their competitors, to customers, suppliers, and interest groups increasingly. The principles on how freedom of information applies are quite different from DPA, Data Protection Act principles, so I'll get on to those. The public may ask to see any information held by public authorities about that, which is any information at all, not necessarily about them, just any information, and any information must be disclosed unless an exemption applies. If you are a company working in, for instance, an outsourced context with a public authority and holding information on their behalf, that information which you hold is regarded as held by the public authority and is subject to FOI principles. There are two forms of exemption from information disclosure. There's an absolute exemption, a yes or no, which either applies or it doesn't, and there's a qualified exemption, which is that the authority has to disclose the information unless a public interest test applies. If there is a public interest test and there's a qualified exemption, the question then is whether the public interest in maintaining the exemption from disclosure outweighs the public interest in disclosing the information. Common exemptions are the fact that the information might be accessible by other means. This is an absolute exemption. So the public authority can say you can get this information in another manner, but it is under an obligation to provide advice and assistance to the person FOI request by directing them to the right source of the information. If information were disclosed and it would inhibit free and frank provision of advice or exchange of views within public authorities, there is a qualified exemption. So we have the public interest test. That is an absolute exemption where this information is held by the House of Lords or the House of Commons. If personal information is the subject of an FOI request and it is subject to data protection law, then there is an exemption. So a public authority may redact a document, however, so it can be disclosed without that personal information. But if there's personal data there, it can't be disclosed if that personal data is subject to the Data Protection Act. It can't be disclosed unless redacted. It's important to note here that there are some cases where the exemption will require the public body neither to confirm or deny that it has the information being requested if it's personal data. For instance, if someone requests information about whether an individual has been officially reprimanded within a public authority, a response stating that the information relating to the request is held but won't be disclosed obviously discloses data in itself because it indicates that the individual has been reprimanded. Other exemptions are where there's a legal duty of confidence relating to the information supplied and held between the public authority and a third party, and disclosure would constitute an actionable breach of confidence. So that's an absolute exemption. If we're talking about trade secrets and commercially sensitive information, where disclosure is very likely to prejudice the commercial interests of another person, including the public authority, there is a qualified exemption. However, the public interest test will normally mean that the information in question has to be disclosed, and you have to have very strong arguments to prevent that. So what about third-party information which a public authority holds? Well, it is, on the surface, fully accessible to the public under freedom of information requests, but it may not be disclosed if its disclosure is prohibited by another law or regulation, or, as I've said before, binding confidentiality. If there is an absolute exemption from disclosure, the public interest test may mean that the public authorities have to disclose on what terms the information in question is subject to confidentiality. In other words, they have to why and how it's subject to confidentiality obligations. If you are contracting with a public authority and you have concerns in this area, it's very important to identify, for instance, which parts of a bid, or contract, or associated material are confidential, and try to make specific claims for these, with reasons which reflect the terms of the Freedom of Information Act. So try to ensure that the public authority is cognizant of the fact that you do not believe these are disclosable. There are some real drive-through exceptions to the exemption regime. For instance, environmental information, there are virtually no exemptions to disclosure. Any environmental information held by public authorities, such as state of human health, safety at sites and so on, is disclosable unless there is a public interest against disclosing it, and that test is very rarely applied to prevent disclosure. So how does an authority comply? It's got 20 working days, or if the public interest test applies, such time as is reasonable. Or the Information Commissioner has said that 40 days maximum if it's going to use the public interest test. A public authority is not required to comply with a request if the cost of doing so would exceed what is called the appropriate limit. At the moment, that is £600 for government departments, the armed forces and Parliament, or £450 for requests made to other public authorities. And in this case, to arrive at 600 and 450, you apply a standard hourly rate of £25. Public authorities may also refuse to comply with FOI requests if they're vexatious, or, as in data protection, if they're repeat requests covering the same or substantially similar areas to a previous and now closed request. Unlike with data protection, authorities have got a statutory duty to offer advice and assistance to anyone who makes a request for information. So, if they require further information from the applicant to identify and locate the information, they've got to tell them that and help them through that. If they don't hold the requested information, but they can direct the applicant elsewhere, they have to do that. If compliance with the request will exceed the appropriate cost limit, but the applicant may be able to refine the request to bring it within the cost limit, then you need to tell them that. So finally, on freedom of information, how is it enforced and who can appeal? If an authority refuses to disclose information which is requested, the applicant goes to the Information Commissioner, who issues an enforcement notice requiring compliance if they consider that to do so is in the public interest. If an authority fails to comply with an enforcement notice, the Information Commissioner certifies this failure to the court, who then deal with the public authority as if they had committed a contempt of court with all the sanctions that that entails. Should be noted here, and this is important to commercial organisations, that third parties who provide information to public authorities have no rights in relation to enforcement and appeal process under the Freedom of Information Act. So they have no standing to go to the Information Commissioner's office, for example. They've also got no right to receive notice before their information is disclosed. For that reason, I would say, just in conclusion of freedom of information, that commercial organisations that contract with public authorities should ensure that in the contracts there is a requirement that the authority gives notice of any FOI request received which relates to information comprised within the contract and takes into account or consults with the commercial organisation's views on the FOI request. So that concludes a rather quick canter through our current position on data protection in an employment context and the Freedom of Information Act. If there are any questions, please do let me have them.
So we've got one here, which is, what is likely to happen to data protection obligations post-Brexit?
Well, that is a $6 million question. My view is that the Data Protection Act itself, although there are some areas, as I mentioned, for instance, in subject access requests, the amount of work which the data controller has to do, which requires some clarification, possibly either by the courts or by statute. Essentially, the Data Protection Act is a relatively sensible and even-handed form of data protection legislation, and it has been in place for quite a long time, so people are used to dealing with it. It won't be ripped up and thrown away. It's very likely that it will stay in place. And indeed, in order for UK companies to continue to transfer personal data and sensitive personal data outside of the UK, there will need to be a regime here which is at least equivalent to the Data Protection Act. In terms of the new directive, again, that may well, notwithstanding Brexit, be put into force by changes to law, because the advantage of doing so allows the UK, even if it's outside the EU, to be treated as a country to which EU-generated personal data and sensitive personal data can safely and legally be transmitted.
What about the Freedom of Information Act?
Well, I'm happy to say the Freedom of Information Act has nothing to do with EU directives. It is an exclusively UK initiative, and so that will stay in place, and there are no plans, as far as I'm concerned, for any changes to that. It has been working quite successfully, and it's certainly popular in a lot of organisations, consumer groups and interest groups, because it allows access to public authority decision making, which was just not available pre it coming into force.
So we've got another one here, which is, we are revising our deselection policy, and our recognised union are wanting us to disclose the ranking of any deselection pool to those at risk of redundancy, so that they can appeal their individual scores in relation to others. We have refused this. Are we correct from a DPA perspective?
Well, I would say that is personal data, and unless that is something which is expressly recognised as a form of processing in your in what you've told your employees, you're probably within your rights to refuse to do that. If it's pushed, it may be necessary. I don't know how many employees we're talking about. It may be necessary, if the matter goes on and you want to try and resolve it, to see whether you can get consents from the people involved. That will be tricky because there's probably a large number of people involved. But it seems to me that that is outside of normal employer processing of personal data. So it's pretty unlikely that there is any consent in place for that. Doesn't seem readily to fall to me within any of the other exceptions for personal data processing.
We've got one more here, which is, what permission should we have before providing employee data, such as date of birth, salary, marital status, pension information, to a third party, in order to provide employee benefits such as income protection and life insurance?
Well, I think that processing is absolutely permissible within the exceptions, and it's clearly, if your employees know that they are entitled to life insurance, pensions, benefits, and so on, that will be a necessary part of complying with that contract with them. So I think that's fine. As a data controller, however, you do need to ensure that the person you're passing that data to has proper security measures in place to preserve the security of that data. Some of that data is sensitive personal data. For instance, marital status. If you're in a civil partnership with someone of the same sex, that is sensitive personal data. And so you do need to ensure that the organisation which is receiving that data has proper security measures in place to maintain the security of the data. If they're a large organisation, which presumably is the case, that should be easy enough, but it is something that you should not just immediately assume, but you should ask them to perhaps let you see their data security policy and data security measures, just so you can tick the box on that.
Great, thanks, John.
Pleasure. Thank you very much.